Commissioner Bush, the meeting is live and the recording has started. Feel free to commence the meeting at your leisure.
Thank you, Corey, and thank you everybody for jumping on. Seeing a quorum online, I think we're ready to get started. Good morning, everybody. The April 21, 2020 School Land Board meeting will come to order. Pursuant to the Governor's executive order to avoid gatherings of more than 10 and the Governor's March 16, 2020 suspension of certain provisions of the Texas Open Meetings Act, the April 21, 2020 meeting of the School Land Board meeting being held today is being held by video conference call as authorized under the Texas Government Code, Section 551, Tech 125. Access to the meeting by members of the public were published, as we always do, in advance in the Texas Register in accordance with the Texas Open Meeting Act. Any member of the public who wishes to address the School Land Board on a matter within the authority of the School Land Board should indicate so at the start of the meeting or during any public comment period. I have the authority to limit the time to each individual that seeks to weigh in on an agenda item. And I believe Corey will be moderating any questions coming in from the public. At this time, due to the extraordinary nature of holding this meeting via Zoom, I believe I'm supposed to ask right now any visitors on the line who wish to speak, and if so, please identify which docket item they wish to speak on, and we will get to you as we get through the rest of the agenda.
Again, those in the meeting in attendee mode are not able to be heard unless you raise your hand or otherwise indicate that you'd like to speak. Please use the comment feature in the notification. Please use the comment feature in Zoom to let us know that you'd like to speak, and you will be recognized at the appropriate time.
Corey, this is Jeff. For those members of the public who are calling in not using Zoom, is there a way to open their lines to see if they have wish to make a comment so don't exclude anybody?
Jeff, I see two phone numbers that are in the meeting that look to be telephone only. I've just enabled those two phone numbers to speak. One of them is the last four digits ending 0442. The other, the last four digits ending 6093. If either of you have a question that you'd like to pose, please let us know now. I see none. Jeff, I should mention that I've received two comments. Bill Hyenga and Blake Hoffman are here to answer questions if needed on items 6 and 7 for Hillcorp.
Okay. If the board has questions for them, then when we get to items 6 and 7, then the board can feel free to ask them at that time. Otherwise, it doesn't appear anybody wants to make public comment on any other docket item. So, Commissioner, I think you can proceed.
Thank you, Council. And again, if any questions come up as we go through the agenda, feel free to use the Q&A section. First time on the agenda is approval of the minutes from our last meeting from February 18, 2020. Mr. Warman was not in attendance in the meeting. Those board members that were in attendance, assuming no questions, comments, or objections at this time, could entertain a motion to approve the minutes from our last meeting.
A motion to approve.
Second.
Motion is made and seconded with one abstention to approve the minutes. Next item on the agenda is the approval of the consent agenda. The consent agenda, since we haven't held a meeting in close to 2 months, it's pretty extensive. I've been informed that item number 2A24 has been pulled from the docket prior to the meeting. In addition, I will recuse myself from items 2C1 and 2C2, 6 and later agenda items 6 and 7 involving Hillcorp Energy Company. But after the board has had a chance to review, assuming no questions, comments, or objections, could entertain a motion to confirm the agenda as it is posted.
Move to approve.
Second.
Can y'all hear me?
Yes.
Yes.
Okay. All right.
And I really appreciate the Longhorn in the background, by the way.
I figured you'd like that.
So we have a motion and a second with one abstention from items 2C1 and 2C2 and the removal of item 2A24 to approve the consent agenda. Items 3 through 6, or I'm sorry, 5 will be held in executive session, and we'll enter into it under Chapter 551, Subchapter D, Section 551, Teco 71 of the Government Code for discussion consideration regarding pending or contemplated litigation or settlement offers, or to seek, receive attorney advice or counsel related to items 3 through 5 on the docket. We'll also enter into executive session under subsection 551, Teco 72 for consideration concerning purchase, sale, exchange, lease, or value of real property related to items 3 through 5 on the docket. And as always, following the executive session, we'll reconvene in open session to complete the docket. I'm advising all visitors to stay on the Zoom call. The board members and essential staff will return to our Zoom call. We're going to enter executive session on a traditional conference line. So it might be easier for the panelists to just kind of stop the video and put it on mute. Corey, is that okay? And then we can just hop over to the conference line?
Absolutely. I will also mute everyone as well. And so when you come back in, I will unmute you.
Beautiful. Thank you.
For those of you on the meeting is underway. The board is in executive session. There's a separate dial-in number for those board members to participate in executive session. They'll be joining us here in a few moments. For those who've messaged me offline to ask for that number, I don't have it right now, but I'm looking for it. Good morning. This is Corey Wilburn. I'm moderating the school land board meeting. The land board is in executive session right now and will be returning momentarily. Those of you in the meeting as attendees are not able to speak. If you'd like to make a comment or if you have a question, please use the Q&A feature or the chat feature within Zoom. Thank you, and we'll be back with you shortly. Coming back in from executive session now, I've unmuted the board members and the panelists. You are all unmuted and should be good to resume as soon as everyone's rejoined.
Your conference is ending now. As requested by the host, please hang up.
If anyone's still on the conference call line, if they could please hang up and we'll return to the Zoom call, please.
I think we're waiting for Gil and Scott to jump back on.
I'm on.
Oh, you are?
Yeah, but
Okay.
for some reason, my camera's not working, but I'm on.
Scott, do we have you? Scott is working here, but working with audio. Excellent. So we got all board members back on. I see that we are recording. so we can reconvene the open session of the April 21, 2020 School Land Board meeting and resume with item number 3. Mr. Mills, I believe, will not be able to present it, and so didn't know if anybody from legal could present it on his behalf.
Well, this is Jeff Gordon, General Counsel. On behalf of Ken Mills, I would, item number 3 is discussion and possible action regarding proposed settlement final audit billing of Chesapeake Operating LLC for certain leases located in Reeves, Webb, and Tarrant counties for the period January 2008 through March 2013. And staff recommends that the board approve the action as described in executive session.
Any questions from the board at this time?
I move to approve.
Second.
Motion is made, seconded, and carries unanimously to approve item number 3. Next on the agenda is number 4.
Ken, are you on now? I see your name there.
Oh, can you hear me?
Yes, we
Yes.
can.
Oh, it's a miracle. Okay. Item number 4, the proposed waiver of penalty and interest on Kaiser Francis. Staff recommends approval of this item as presented in executive session. I'd be happy to answer any questions.
I move to approve.
Second.
Motion is made, seconded, and carries unanimously to approve item number 4. Next item on the agenda is number 5.
This is Russell May. I believe David Wells presented it. Staff is recommending the approval and disposition of PSF land under the attached terms and exhibits as presented in the executive session in the best interest in the state of the PSF. Any questions?
Motion to approve.
Second.
Motion is made, seconded, and carries unanimously to approve item number 5. Next item on the agenda is number 6.
This is Robert Hatter with Energy Resources Division. Item number 6 is a request by Hillcorp Energy Development. They've applied for a temporary suspension of state leases 119324, 119325, and 119326. These are PSF leases in East Bay and Galveston County. In order to drill a well in state waters, you have to have an oil and gas lease from the GLO, obviously, but you also have to have a oil field drilling permit from the Corps of Engineers. Hillcorp bought these leases back on April 3rd of 2018. In November of that same year, they applied to the Corps for an oil field development permit to drill the well, a well on the unit. There was a unit created called the Hillcorp Tarpon unit. The board approved that on April 2nd, 2019. Under section 52.0301 of the Natural Resources Code, if a state lessee is unable to obtain access to a leased property or is unable to obtain in a timely manner a permit to drill on or produce on state-owned property, they can request a temporary cessation. They have still not received a permit from the Corps, and so staff is recommending that the board suspend the primary term of the underlying leases for a period of 12 months so that the next anniversary date for each lease will be April 3rd, 2021. I'd be happy to answer any questions.
And I want to remind the board that there are some representatives of Hillcorp here as well, if the board had questions for those representatives.
I move to approve.
Second.
A motion is made, seconded, with one abstention from the chairman to approve item number 6. Next on the agenda is another Hillcorp item.
Robert Hatter, Energy Resources again. This is a very similar request, almost identical. It's for state lease. It's from Hillcorp Energy Development. A request for temporary suspension of state leases 119354 and 119355. These are leases to the east, or excuse me, to the west in Trinity Bay and Chambers County. Similarly, these are leases that Hillcorp bought on April 3rd, 2018. In October of that same year, they made application to the Corps to receive an oil field drilling permit. The This is on the unit called the Hillcorp Beluga Unit. It was approved by the board on April 2nd, 2019. Since Hillcorp, the one difference between this and the previous item number 6 is since Hillcorp made a request for suspension, they have since obtained a drilling permit, a oil field development permit from the Corps that was recently received. However, there were almost 17 months during which they were not able to develop the tract, and so staff is recommending the same, making a recommendation that is the same as item 6, which is to recommend suspending the primary term for a period of 12 months. So the next anniversary date of each lease is April 3rd, 2021, to allow them to recoup 12 of those 17 months that they were unable to act. Be happy to answer any questions.
Motion to approve?
Second.
Motion is made and seconded with one abstention from the chairman to approve item number 7. Next on the agenda is number 8, the big issue of the day.
Again, Robert Hatter with Energy Resources. Docket item 8 is consideration and possible action on adoption of a policy addressing one or more waivers of penalties and interest on late royalty payments and reports submitted between April 1st, 2020 and June 30th, 2020, and a grant of a 6-month extension of time for drilling commitments during 2020 and a total 90-day tolling period on calculations and enforcing lease terminations for cessation of production or failure to produce in paying quantities or any other temporary relief that the board may determine is in the best interest of the permanent school fund. Basically, I'm sure everyone's familiar with what's happening now, but just to go over it very briefly, due to oil demand destruction caused by the COVID-19 virus, a general oversupply of crude oil on a global basis, and the near-term lack of sufficient oil storage capacity, GLO has received numerous communications from the industry concerned about their abilities to timely meet their drilling commitments and completion commitments on state lands, timely file production reports, and even to sustain oil production in the current economic environment. In response to these circumstances and to conserve the state's oil and gas resources during this low price environment, GLO staff recommends that the board consider and adopt the following temporary policies. And so basically restating, but in more detail, what I read as far as the docket item. Policy number 1, temporary policy number 1, be to delegate to the land commissioner the authority to waive excuse me, penalties and interest on late production reporting requirements and late payments of oil and gas royalties during the reporting period from April 1, 2020 to June 1, 2020. Number 2, delegate to the land commissioner the authority to grant extensions of time not to exceed 6 months in duration for the satisfaction of contractual oil and gas well drilling and completion commitments in state oil and gas leases and associated drilling agreements governed by the board. And B, to confirm the land commissioner's authority to grant extensions of time for the satisfaction of contractual oil and gas drilling and completion commitments in state oil and gas leases issued under the Relinquishment Act if the owner of the soil ratifies such extension in writing, and in both instances where it is deemed by the land commissioner to be in the best interest of the state to grant such an extension, including in order to conserve the state's oil and gas resources. And number 3, confirm the land commissioner's authority to declare a period of tolling of up to 90 days under a state lease, whether issued by the board or under the Relinquishment Act, which tolling period will not be counted towards the time period under an effective state lease, after which the state may terminate the state lease for cessation of production or for failure to produce in paying quantities. I'd be happy to answer any questions.
This is Todd Williams. I have a question on 2B. Is there a time limit on that item, on that authority?
There's not currently. Certainly, these are intended as temporary measures. The board could certainly do whatever they choose, but we could set a time limit of, say, December 31st, 2020, or unless previously revoked by the board, or set some time frame that y'all think is reasonable. I think we're going to know a lot more in 3 to 4 or 5 months about where the oil market is going as far as demand destruction by the virus and also issues we've got with oil storage.
Yeah, I'm in favor of this policy. I guess I would probably argue for some sort of time limit on 2B, just so that we can relook at the facts and data.
Okay. Is there a specific time period that you like?
What you suggested is fine. December would
Okay.
be fine.
Okay. All right. We'll adjust the policy to add that if the board approves that.
And Robert, if you could, unless the board had any other questions, could you talk maybe a little bit about just the diligencing of new producers to come onto state lands and to release, and what that means from a manpower standpoint for the agency in the event that we have a wide scale termination of agreements or leases on state lands, and how that looks? In other words, is it economically better for the PSF to keep our producers or at least help at the margins in terms of keeping them solvent moving forward?
Yes, sir. Currently, we have quite a number of large operators out there, a major and some very large independents. Currently, they have a significant amount of money, billions of dollars invested in the infrastructure out there. If we were to allow these leases to terminate, I think we might get acreage back, certainly, but it's going to be scattered pieces of acreage that may not be as valuable as allowing these same operators to hold those leaseholds in a block so that they can orderly develop the tracts.
If I could throw in real quickly, this is Ken Mills. Also, Commissioner, I think in response to your question, Robert asked, the resident PhD to do some analysis to try to determine. It's a lot of guesswork because no one knows what market prices are going to do, but that the impact on the school fund, while there may be some loss of revenue down the road as a result of some of these forgiving kinds of proposals we're making, it seems far outweighed by, as Robert was saying, just the practical ability of the existing operators we have with money in the ground already to try to help them keep going, because in the long term, that's going to be better for the mineral estate that we manage, even if there's a short-term hit to revenues.
Yeah. And generally speaking, I mean, it's been a while since I've looked at, the credit rating of all the producers on state lands, but for the most part, we have large scale operating companies that are on state lands. I mean, we do have exposure to some of the non-investment grade quality credit rating, but we have pretty solid balance sheets on state leases, correct?
Yes, sir. We have large companies out there. We have some of our major lessees are out there. Large lessees are Chevron, Cimarex, EOG, companies that are going to be stable and hopefully make it through this situation, certainly. I also have some private equity backed lessees out there on PSF lands, and so they may be more critically hit than the larger companies that are well funded.
Any questions from the board?
Robert, I would just say that, from the perspective of where oil prices go, I think it would be safe. And if you look at the curve, the crude oil curve, it's pretty much going to go through 2021. I think we're going to have to get in 2022 before we start to see some real appreciation on crude oil pricing. So I'd run some cases on that basis.
Yes, sir. As Ken mentioned, I had our resident PhD petroleum engineer who also has an MBA do an analysis of the financial impact of well deferral on the PSF. He did that study on April 16th, and as Ken said, it doesn't show a substantial hit to the permanent school fund by delaying these wells, and I'd be happy to share that study with anybody who would like to see it.
I'd love to see it. Thank you for that.
Yes, sir.
And I think, Hatter, to confirm and what you and Ken have both said, these are temporary measures taken by the board. And most of these are somehow as far as just extending the time in which operators have to drill. So I think the argument could be made, this certainly is in the best interest of the permanent school fund to not make them expend more capital in this current market environment. And then we can look 30, 60, 90 days in and see if additional measures are required or see if there's some type of rebound that we can come back and kind of tweak these at any time.
But very fair. It's very fair.
Yes, sir. Well, the staff would recommend adopting the policy with the caveat or the change that these measures expire on December 31st of 2020.
Motion to approve.
Second.
Motion is made, seconded, and carries unanimously to approve item number 8 based upon the modification that Robert mentioned that Todd recommended. Thank you for that, Todd. Next on the agenda is number 9.
Commissioners, this is Ken Mills, Director of the Oil and Gas Section in Office of General Counsel. Item 9 is a proposed adoption of an amendment to our commingling rule. This is in 31 TAC section 9.35. The proposed amendment would revise existing paragraph A2, which primarily has to do with the quantity and frequency or quality and frequency of metering. And it also proposes adding a new paragraph A4 dealing with certain de minimis issues. I'd be happy to answer any questions, particularly for the newer board members, about what commingling is or what the rule addresses. But in short, this item was approved for publication in the Texas Register. It was published on January 24th of this year. We received a handful of comments, all of which were in support of the amendments. I will say that these amendments were discussed at length with industry. There's a lot of industry participation to make sure that while what the school fund needs in the way of reliable audit information is information that can be gathered through metering technology that's acceptable on a cost basis to industry. So all of the comments we received on the proposed rule were positive, and at this time, staff would recommend that the board adopt these changes and have this adoption published in the Texas Register. As I say, I'll be happy to answer any questions.
Motion to approve.
Second.
Motion is made, seconded, and carries unanimously to approve item number 9. Next on the agenda is number 10.
Morning again, David Wells with Asset Management. Item number 10 addresses rent abatement for our Chapter 33 leases along the coast. Typically, we're talking about piers, docks, marinas, fishing cabins, structures associated with littoral ownership down along the coast. And basically what we're coming to the board to recommend is delegating authority to the commissioner to grant rent abatement for up to 1 year under Chapter 33 for any leases that fall under that category. The abatement will be done on a case-by-case basis. It'll be reviewed by asset management or coastal resources. And so far, the way we're doing this and addressing it is on a month-by-month basis and not doing it ad hoc. And additionally, at least on the commercial side, I'll let Tony speak for the residential side. The majority of our leases pay annually, so it affects a very small portion of our leases. Tony, anything you want to add?
That's correct. All the residential easements are on an annual basis. We've had almost no residential requests to address rent, but we do anticipate some coming in as this continues. We have a little over 2,000 residential easements that will pay rent over the next year. Any questions?
Do we know what roughly the total income from what is potentially being deferred here?
Currently on the commercial front, we've only received communication from approximately a handful, 5 lessees, and we're talking somewhere in the $10,000 or under range. I don't know on the residential side, maybe. I guess, Tony, you said you haven't had any.
We haven't had any.
People reach out.
Most of the residential easements are less than $1,000. So if we do get any of those, it would be in that kind of price range.
Okay.
Are you talking about $10,000 per month or $10,000 per year?
So far, we're only doing it on a month-by-month basis, and the handful of commercial lessees that have reached out to us, the total for those lessees per month would be in that neighborhood of $10,000. But again, that changes as we hear from more people or people continue to pay their rent, those sorts of things. So $10,000 per month is what I was referring to, but so far we've only intended to address 1 month, and then we'll continue to address it each month as the situation continues.
And refresh my recollection again, our Harvey policy was it a year long as well on all coastal leases or just the residential easements?
Right. So with Harvey, what we did was we did a year of rent abatement for coastal leases that were affected more than 50% by the hurricane. And we did that across the board. So I don't recall the total off the top of my head, but it was a far greater number than what we're talking about in this case. And in that case, any lease that qualified that was more than 50% damaged, we gave them a year of rent credit. And at least on the commercial side, I'm not 100% sure on that number, but it was in the 200,000 range, I think, is what it ended up being for an entire year.
And when staff reviews these requests, will there need to be a tie to COVID-19 or not, or any kind of economic impact?
Right. So we'll look at it on a case by case, depending on the type of business. Typically, the businesses that we've heard from so far tend to operate restaurants or marinas, businesses that have been closed down where their cash flows and their incomes have been severely impacted.
I move to approve subject to there being an actual adverse impact from the COVID virus.
I second.
Yeah, I would agree with that.
Are you just, this is Michael. We, I'm at a commercial bank and we're dealing with the Paycheck Protection Program. I'm sure y'all have heard about it. All we're required to do is have the borrower attest that they've been affected, and that's the extent of the due diligence. So are y'all suggesting we do more, or do we just have them attest and go?
Typically, we have them provide information, and then we'll evaluate based on what we know and the type of lease and the local conditions. So we haven't received enough of these, at least yet, that we have a standard form or anything like that. So it's a judgment call on asset management and coastal's basis.
Yeah,
I'm willing to delegate. That's a good point, Michael. I'm willing to delegate that determination to the staff and the commissioner.
I agree.
Well, perhaps council can wordsmith some language recommending at least some sort of causation or connectivity to COVID-19.
I think what the motion is that y'all are discussing is move to approve the recommendation subject to staff's review and determination as to whether or not the request by the lessee is caused in some way by the pandemic and the economic problems associated with it. Does that sound about what you all were looking at?
It does for me. And I think, and again, my other thing is that these are month by month decisions made by staff, correct?
Correct.
Okay.
Can we make said motion based upon that wrangling?
Yeah, I'll re-up my motion based on Jeff's language. That's fine.
Second.
I think a motion is made and seconded and carries unanimously to confirm item number 10. Any other questions from the public via Q&A? Any other last comments from staff that I need to be aware of before we hereby adjourn?
Commissioner, there's been nothing come across through the official Zoom communication channels.
Excellent. There being no further business before the board, the meeting is officially
I'm
hereby
sorry,
adjourned.
Commissioner. We've got one coming in for the last second, of course, from Susan Carroll.
Well,
Susan Carroll,
and for the record, the point of this is to take public comment. The board is not required to answer questions, but if anybody member of the public wants to make a comment, they certainly can, but this is not a Q&A session. I just want to make that clear.
Understood. General Counsel, the question from Susan Carroll is, what is the balance of the permanent school fund?
And that is not information we have right there. I don't think anybody on the call directly has that, but certainly Ms. Carroll can submit that question to either comms or our open records, and we can get that information. I don't believe we have that. I don't know of anybody on the call who would have that handy at this point.
So noted. I will indicate that in the meeting minutes. No other questions, sir.
Excellent. We can hereby adjourn.
Thank you all.
Thank you, everybody.
Thank you.
Thank you. Stay safe.